Yeah, let's get chapter 22. Kind of before we get started, though, I'd forgotten to talk about this, and I wanted to because I think this is kind of a huge deal. The Texas federal court stays implementation of new FLSA, which would have applied more to chapter 21, so I'm sorry. I should have talked about it in the last deal, but this is brand new, November 30th of 2016. So just last week, this order was stayed. And what had happened was President Obama had decided that the old limit, the exempt versus non-exempt is what it's called, and exempt employees are those that are paid a salary, and you can work over 40 hours a week and still get your salary. You're not subject to the time and a half that non-exempt employees are entitled to. Okay, and the before, there's only been a threshold really for probably the last been in the last 10 or 15 years. And the reason for that, maybe it was a legitimate reason, was that, you could call somebody a supervisor and didn't matter what you paid them. You could subject them to work or ask them to work or make them work, 60 hours a week and still pay them a salary, right? And so they had put in a limit. And the old limit, I'm not sure if it's in here, but the old limit I want to think was right around 20. It says for 35.1, but I don't think that's correct. I think that the current limit's closer to about 24,000. And I might be wrong on that. This one's showing 35.1, but this could be New York, because this in New York, and they may have a separate amount. I think the U.S. standard's about 34 or about 24,000. I'm sorry. And Obama's administration was going to increase that through apparently an executive order or through an administrative action to close to 48, $48,000, about $4,000 a month. Meaning that anybody that was paid less than that could not be considered a salaried employee. They would have to be paid by the hour so that they could receive time and a half if they worked more than 40 hours a week. I have to admit, while I think the original proposal maybe to put in some limit was okay, 48 grand, that's getting up there, especially for a nationwide. That perfectly appropriate in New York. I'm sure San Francisco will let them adopt whatever rules they want. I'm not sure in Montana that's that appropriate. And I say that if I went back and kind of applied that when I was in my banking days, and granted, we'd have to make adjustments for inflation and those types of things, but there was a lot of years where I'm sure I'd have made less than that, the equivalent of that, back in those years, and yet I was salaried. I really had no complaints about that, and probably my biggest issue would be this, is that I never knew when I was on the clock or off the clock, and I didn't care, and it would have been a hassle to have to worry about that. And what do I mean by that? Well, Ducks Unlimited banquet came up, and the bank had tickets for the Ducks Unlimited banquet, and they needed somebody to represent the bank to go to that. Well, would I have been on the clock? Geez, I get to go to have a free dinner and on and on. How about when I was out golfing? I mean, I did more business on the golf course probably one night than I did in a whole day of work. Was that on the clock or off the clock? I was playing for the team. I was team captain, all that other good stuff. Those things would have been extremely confusing for me. They would have been extremely confusing for my employer. I'd imagine would have made it difficult for my employer. I mean, they'd have been afraid that maybe I'd sue them, right? If I was a relatively new employee, especially, if they said, here, take these tickets and go to the Ducks Unlimited or I went to banquets, Pheasants Forever, Highline Tavern Association, you name it, okay, representing the bank and not necessarily getting paid for it, okay, but that was okay. I didn't mind. I was there. I was doing good for the bank, and I was enjoying myself as well. So, all right, now let's jump then into our conversation here. And let's take a look at this. So now we get to talk about unions, right? So brief history of unions. Gosh, I can't talk now. So anyhow, the Knights of Labor, right, originally established in 1869. So one of the first U.S. Unions, right? It kind of disbanded during the Depression later in 1873. Then the American Federation of Labor, which really still exists today, started in 1886, or the American Federation of Labor, or the AFL. Okay, it's a federation of unions of skilled workers only. So what do we mean by that? We mean that, I guess in today's day and age, probably didn't have it in 1886, but you would have electricians, you might have plumbers or pipe fitters or boiler makers, those types of things. Back then you probably had iron workers, horseshoe makers, I don't know, okay, what the classifications might have been, but they were skilled workers, right? And they would organize then to promote their trade and to try to receive fair prices and whatnot for their trades, okay? The Pullman strike of 1894 was the first major strike in the U.S., and it wasn't carried out by the AFL, it was carried out by another union. But the Pullman strike, and you guys wouldn't remember this, but and I wasn't quite alive then either, but I've read about it anyhow. The Pullman cars, if you go back and study railroad history, you'd find that Pullman cars were a big deal. They were a big car maker, or not cars like we think of it, but cars, railroad cars, and they were a big manufacturer of those. And in 1894, the workers went on strike, want better pay conditions. I don't know what all the things were. And it concerned the U.S. government so much so that it would cause economic harm, because not having, railroad cars on the railroads to transport goods and services and those types of things would have been a major hassle. And so the government ultimately set in troops to end or quell the strike. I think there was even shots fired. There might even been some people killed. That I don't remember. But, the government was definitely, at least at that time, pro-business, okay? One that I kind of threw this in here just for the heck of it, but the IWW, the Industrial Workers of the World, often called the Wobblies, and I throw it in because they used to have a pretty big presence here in Montana. I don't know if they had a bunch of union members necessarily, but I think one of their offices used to be in Butte, and they might have had some union members and whatnot. Promoted socialism, and still do. I mean, they've got a website, you can kind of look it up and whatnot. Again, I don't know that they have any members necessarily, but any union members or represent any unions. 1935 saw the formation of the Congress for Industrial Organization, the CIO. Okay, so in 55, the AFL and the CIO merged, and we have that today as the AFL-CIO, which was anyhow one of the bigger unions. That said, I can tell you that union memberships is decreased as a factor in our whole employment scheme here in the United States. Union membership, especially in the private sector, is become very, very minimal. Okay, what the CIO did, I should jump back up there, but it organized entire industries regardless of the skill. So we had auto workers. Within auto workers, you had numbers of different skills, right? You might have had metal workers, electricians, engine workers, tool workers, whatever it might be, right? But they would all be unionized then as automakers, right? United Auto Workers, basically. And so that's what you saw for the CIO versus the skills that you had for the AFL. So, yeah, employment and labor laws are really emotionally, right, and politically charged topics. They go to the heart. We saw a bit of a shift. Typically unions have supported Democratic presidential candidates in the past, and we saw a bit of a shift where, especially law enforcement unions, which are public unions, but they crossed over and supported the Republican candidate for president this last time. And so that was kind of an interesting when we look at the political shift that has taken place there. Okay. Lots of battles, between unions, employers, still ongoing. Okay. Big battles took place in the past, and we'll talk about a few different things here. So, introduction. Anyhow, labor law prohibits unfair labor practices, and there has to be good faith collective bargaining. So if the employees have set up a union, the employer is obligated to deal with that union in good faith, right? And labor laws develop standards, rules, whatever, for relationships between employers and their union. So I think we talk more about what some of the unfair labor practices are here as we go along. So union workers, right? Organizing collective voices to increase ability to communicate with the employer. Yeah, to have a united voice, I think, might be a better way to say it. I don't know that it really increases their ability to communicate with the employer, but it certainly gives them a united voice. And with the current way or union laws and whatnot, mandates, of course, that the employer has to deal with them. Inherently, neither good nor bad. And what do we mean by that? Well, gosh, you look at right to work states versus non-right to work states, and on and on and on, and you can make a ton of comparisons, and you could make a lot of arguments both ways as to which are better or worse. And it's really difficult to say that unions are either good or bad, that they're providing a great benefit, or that they're not, they're providing harm. Hard to say. Largest unions now represent teachers, government employees, and service workers in the private sector. Have become the biggest ones. Okay, so we've seen the private workforce union representation really drop. Okay, public workforce, which is your teachers and government workers and whatnot, have maintained pretty well. So some of the laws that have passed. Of course, the Clayton Act we dealt with when we dealt about antitrust, right? And it exempted unions. So unions can have a monopoly then, right, on the people that they represent. And the Clayton Act is specifically put in that exemption. The Railway Labor Act, right, created collective bargaining for railroads and airlines. Wow. Set up a mediation board, right, to work through some issues and whatnot. Norris-LaGuardia Act in 1932 was a fairly major union act, and what it prohibited in this case was yellow dog contracts. And you guys probably want to know and need to know what a yellow dog contract was. And at the time, they were fairly commonplace, that a employer would agree to hire somebody, but only if that person agreed that they would not attempt to join or organize a union. Okay, so the employer would put that right into the contract for new employees, thus preventing, hopefully, the formation of a union within that work site. And the Norris-LaGuardia Act prohibited yellow dog contracts, said that employers couldn't do that, and prohibited certain court actions from employers basically against employees. So we were starting to see a shift here, maybe towards employees versus employers and some of these negotiating and whatnot. The big one that came along here, and again, remember we had the SEC things, Securities and Exchange Act, and those things that took place during the Depression. And midway through the Depression, you saw the Wagner Act, or the National Labor Relations Act. Okay, so know this is both called the Wagner Act and the National Labor Relations Act. Okay, it created the NLRB, or the National Labor Relations Board, which is still around. And it's one of those administrative agencies or boards, that we talked about in Chapter 16 or something. Okay, they regulate business that's affecting commerce, right? Small employers are generally covered under state laws. Okay, and it granted the NLRB quasi-judicial authority, which similar again to other agencies, right? Meaning that the NLRB can arbitrate, maybe for lack of a better word, or adjudicate let's call it that, adjudicate actions that happen between employers and employees in that union sense when it's a collective bargaining issue. So it's it's an independent agency. It means it's not an executive, it's not under the auspices of Congress. It's set up, and granted, their people are appointed and whatnot by the president and confirmed by Congress. Okay, but they're kept separate then. Okay, and again, they have jurisdiction over any business that's affecting commerce, judicial hearings, et cetera, et cetera. So personnel that are exempt from NLRB, those covered under the Railway Labor Act, so they kind of have their own thing going on, right? Employees who work for their spouse or parents, household domestic workers, independent contractors, government employees, interesting, aren't covered by that, and egg workers aren't covered by that. So kind of like some of those exemptions under the antitrust thing, you shake your head and you don't know for sure why, but oh well. When they talk about setting up unions, right, it says an employer may voluntarily recognize and bargain with the union. It doesn't necessarily happen that often, but it can. I mean, I suppose if the employer knew that it was going to happen, why not then become a willing participant and get her done, show good faith towards the workers at the beginning, those types of things, right? Otherwise, it takes NLRB certification of a union. And the certification process is simply this. So a petition needs to be circulated amongst those workers that might potentially want to be covered by a union. And that petition, if it were signed by 30% of those people, okay, that could potentially be represented by a union, then the NLRB would be called up to conduct an election, a certification election. At that point, if 51% of the ballots were in favor of it, then you would have a union representation. You could have followed this actually at Bozeman at MSU, our mothership here, a few years ago, and they went through both certification and decertification in a relatively short period of time. One year they had petitions go around, and they had enough people, so they conducted a certification election, and sure enough, it passed. It wasn't, 2 years later, maybe, and a petition went around, and they got enough. They got enough people to sign the petition that they had a decertification election, and sure enough, they became decertified. So right as we speak, MSU no longer has union. Their faculty, I don't know about the rest of their staff and whatnot, but their faculty are not represented by a union, as opposed to Northern. Now Northern. And I admit I find this to be kind of strange in terms of the law. Northern has been represented, to my knowledge, by the same union for decades and decades and decades. And my mother taught here years ago, and I asked her if she had ever had the opportunity to vote on whether or not she wanted to be represented by a union, and she could not remember. Okay, I've never had that opportunity, and I've been here 15 years now to vote on whether or not I want to be represented by the union, which of course we're forced to be. And we'll talk about that, I think, when we talk about some of the union rules, but Montana's not a right-to-work state, so we're forced to become a part of the union. I just find that interesting, that there's not any kind of an ongoing certification or decertification process, but I suppose it allows for some continuity or something, maybe in this case. But the decertification process is just like the certification. So if we are, then, I might lament the fact that I haven't had a chance to vote on it, but certainly I could offer up a petition, and if I had enough of my fellow faculty that wanted to and signed it, it'd probably take about 23, 24, 25 people to sign it, then we would have an NLRB certified election to see whether or not we wanted to decertify. This certification through cards, and what can happen here is if, let's say, this petition got over 50%, okay, basically the employer could choose to just go ahead and recognize the union. And right now, that's a voluntary thing. There was a push to make it a mandatory thing, and in fact, the law got, I think, made it through one of the houses of Congress, but not the other. That would have made it mandatory if they receive 51%, that it would be that the employer would be forced to recognize the union. Employers fought this, and why? I mean, gosh, if there's 51%, they're going to vote on it, right? Well, what what it would have prevented them from doing is campaigning against union formation. So when this election gets set up, I mean, it's down the line a bit, and so there can be a little bit of campaigning and a little bit of back and forth and discussion and those types of things. This would have prevented that. I mean, literally, you might have been able to have a pizza and beer party one night and get enough people to sign the certification cards that the employer would have been forced, right? And enough beer or something flowing, could have been kind of a mess, I guess. And so the employers fought it and said, hey, we want a chance to be able to discuss these things with potential people that might want to form a union. So again, here at the very height and back, at post probably, or right at the very end of World War II, we hit the height of union membership, about 35.5%, so huge. Well, we'll talk about reasons we don't have as many union members now as we did then, but then you see it's really dropped. I mean, the private down to 6.6. I think it's lower than that now. I think it's under 6 maybe now. Public is starting to level off, so we're seeing a decent what would that be, 5-6%, whatever. I mean, a lot of the public employees are still members of the union. So why? Why are we seeing a steady decline in union membership? Well, aggressive opposition from business, right? You guys have probably seen reports about Walmart and what they've done and whatnot. Okay, they aggressively have opposed union formation. So much so, I mean, I can give you a couple of instances of things that have happened. They had a couple of stores in Canada that voted to become union stores, to be represented by a union, just at those stores alone. It was within a year those stores were closed down. Now, Walmart claims it was for other reasons, but it's kind of hard to deny. It seemed like quite a coincidence. That might have been a violation, but it was in Canada. I don't know what their laws are. In the U.S. now, what happened here was with their Sam's Club, which Walmart owns, but they used to have meat cutters on staff, in their Sam's Club stores and whatnot. And those meat cutters voted to join the meat cutters union, and Sam's Club or Walmart had fought against that and had warned them, and they went ahead and voted to become union members. And it was either the same day, I think, or the next day. Walmart fired all of them, and they can do that. And they said, well, we're just going to outsource our meat cutting. And so we would, in other words, Walmart just basically is buying those things already cut, prepackaged, and put them in their stores, and they sell meats that way, as opposed to having their meat cutters represented by a union. So, I think that shows you some aggressiveness. Was that legal? Yeah, that's legal. I said day or day after, and it might not have been that quick. They might have said, hey, we're not going to meet your demands if the union had certain demands, and so just said, yeah, we're not going to do it. Perfectly legal in that case. Do they have to bargain in good faith? Yeah, but bargaining in good faith doesn't mean that you have to meet any of those terms, and so that ended up happening, and it was perfectly legal. New workers have no loyalty to labor organization. Women and teens, typically labor or unions were formed around, the blue collar, the old manufacturing, Rust Belt types of jobs, and a lot of the newer jobs don't have a history of union representation, and so the women and teens that have entered the workforce, those old blue collar jobs were typically male jobs, construction, mining, oil rigs, whatever the case may be. As women and teens have joined the force, they just don't have that same loyalty to labor organizations, and victims of their own success, and this was pretty important. Labor was. I mean, I'm not a huge union guy. I mean, I'd like to have that opportunity to maybe not be a part of the union, but I would be remiss if I didn't say that labor unions have been responsible for a great number of changes that we've had, and most people would argue positive changes in our workplace. Um, you know. Hours, number of hours in a work week, overtime laws, those types of things oftentimes were a result of labor unions, right? And so what happened is they would get those rights at the places where they worked and whatnot, and they became good and they became accepted, and then ultimately they became law. And so unions kind of created a lot of the labor laws that we have that cover non-union workers as well, and so people just don't think it's as important maybe to be a part of a union. And you'd have to argue too that one of the reasons we're seeing declines is we don't have that manufacturing, mining, and that type of base that we had in the past. We still do a decent amount of that stuff, but a lot of that's through automation, and it just doesn't take as many people, actually workers. And our new industries, the Googles and the Microsofts and the Apples and those places, well, they have a number of employees. They're really well treated as it is, and probably don't really have any huge desire to be a part of any kind of a union. Kind of by industry, kind of old, but education, right? Okay, and then government. And you see some of the, construction workers are still, pretty kind of widely represented. You still have electricians, you still have plumbers unions, you still have those types of things. Telecommunications, that's kind of interesting. It might be your AT&T and some of those, some sales, etc. So, unfair labor practices by management. So these are things management cannot do, right? Interference with concerted activities. So the union can get together, right? They can have meetings, they can talk about what they want to do, they can do those types of things, and they can have plans of action, and management's not allowed to interfere with those things. They cannot discriminate against employees based on their union affiliation, okay? Or union desires. There was a case in, I think it was Miles Community College, where there was a professor that passed around a petition. The professor was eventually let go by the college, and while again the college claimed it was for reasons other than his union activism, he sued. I don't remember what the outcome was, or if we ever saw it. It might have been settled out of court where we wouldn't have seen it. Can't allow domination of a labor organization, can't allow the employer cannot dominate the labor organization, so they can't infiltrate that, tell them what they're going to do, and do those types of things, right? And again, can't discriminate as a result of the NLRB proceeding. That's the Miles Community College case I was telling you about, right? Cannot refuse to bargain with a union. And that bargaining has to be in good faith. Oops. So some compulsory bargaining issues can include wages, okay, hours, terms and conditions of employment, number of hours per week, what hours they're open, those types of things are fine. Voluntary internal union business. So, employers can talk about that a little bit, maybe. The union doesn't have to answer that, So would it be okay for an employer to bring up, you guys have your union boss is just a really pain in the butt to deal with? That they can, and the union can say, well, go to hell, we're not going to talk about it, but they can if they want to, and vice versa. Union can say, hey, the boss or the person we're negotiating with from the management side's a real asshole. Do we really have to deal with them? And and it can be discussed, but it's not mandatory. Designation of negotiators. Again, not mandatory. Making transcripts of negotiations available, again, not mandatory. The NLRB and the courts often must determine, right, if the bargaining issue is compulsory or voluntary, and so there's probably some gray areas in between here. right? So in 1935 was the Wagner Act, right? And that that was really the first major act dealing with union and organization and those types of things. And it was in the Depression, and we had the end of the Depression, and then we had World War II roll along. And in 1947, there seemed to be a push. Business was trying to move forward and whatnot, and there was a sentiment that maybe the Wagner Act had gone a little bit too far. And for example, one of the things that the Wagner Act did basically was prevented management from even campaigning against union formation. So if they wanted to come in and organize the union, the management couldn't say anything about it. Okay, they couldn't participate in that discussion whatsoever, and Taft-Hartley undid some of those things, right? Okay, it did kind of I would say evened the playing field. I think most people would agree that it was probably even the playing field. It was designed to ensure the free flow of commerce, meaning that it also gave maybe the government a little more ability to intercede and make sure that commerce was going to proceed when necessary. 80-day cooling off period was put in place, meaning that when it's of vital importance, when it's of a national importance, the government can step in and tell both sides that they have to quit bargaining, quit doing those things. There's a cooling off period. So they're going to go back to work, okay, and then in 80 days they would come back to the table and resume negotiating. Again, when you get those big high emotions and those types of things going on, it's easy to understand how things can get kind of crazy. So the 80-day cooling off period kind of allow both sides to settle down a little bit before they get back to the table. The management free speech, and again, the Wagner Act kind of prohibited that, kind of didn't allow management to even mention, that, hey, it might not be a good idea for you guys to join the union. Okay, and this certainly allowed them to then come back, negotiate, or campaign, if you will, against union activities and those types of things. Federal Mediation and Conciliation Service, and so it set this up so that when there's impasses, that the government could provide mediation services to try to overcome some of those impasses. Free speech. Statements made by employers frequently were targeted as unfair labor until Taft-Hartley, right? Okay. And that's kind of what I was talking about, right? The expressing of any views, argument, or opinion, or the dissemination thereof, whether written or printed, graphic or visual, shall not constitute or be evidence of an unfair labor practice. And so, again, the Taft-Hartley kind of allowed them businesses to, employers to be a little bit more free in what they spoke of and whatnot. So, union shop, okay, and union shop is what most places are, and talk a little bit about that. But a closed shop they're illegal now. Okay, closed shops are illegal, but a closed shop used to make it illegal to hire somebody if your employees were already represented by a union. You had to hire another union member. In other words, if somebody wanted to work for that company, they actually had to join the union first before they could even apply to work for that company. Okay, and that became illegal. But the union shop then became far more common, and that said that an employee can be compelled to join the union then if the current employees are represented by a union and the management hires somebody, they get to pick, and it doesn't matter, it's whoever the employer wants, okay, but that employee can be required to join, okay, within 30 days. Okay. And in most cases, that becomes a part of your employment workbook and stuff that you get the first day of work. You just sign up and whatnot. Agency shop says that there can be dues required, but you don't necessarily have to participate then or be an active participant in the union activities. And I believe Montana is kind of an agency shop. I think that I could kind of opt out of union activities and say that I don't want, and in fact I can have part of my dues reduced, and that would be the part that goes to things that aren't actual union activities. So our union, for example, spends a decent amount of my money on political issues and whatnot. Okay, and I could say, hey, if that's if that's 50% of my union dues, I want my union dues dropped by 50%. I think I can do that in the state of Montana. Okay, and then I wouldn't be an active participant in the union either if I did some things like that. And it's kind of fun to go and listen to them. So right to work laws, and I think about half the states, not quite, I think it's 23 maybe out of the 50, have right to work laws which say that a person cannot be compelled to join a union. So it kind of throws the union shop mentality out. It says a person cannot be compelled. So you get hired, if there's a union, you can say yay or nay. And there's right to work states. It's kind of funny how Montana's surrounded by right to work states, the dark green are the right to work states. Montana had a long history, and it was an eventful history of the old Copper Kings. And, for a relatively short period of time in our history, but a real boisterous time, they kind of ruled, and they ruled with a heavy hand. And so when they got thrown out, there was a big backlash, and it's still well remembered in the state of Montana. And so there's still a lot of history of union activism in the state of Montana, and again, some of the positive things that they did with the Copper Kings and whatnot. And so Montana remains kind of a pro-union, I guess you would say, state. And part of one of the big reasons we have not become a right-to-work state, I think, is more because of that history than anything. We haven't had a chance to vote on it for a long time. I don't know what that vote would be now. So the Landrum-Griffith Act, if you want to remember dates, I don't think I require that, but they're all 12 years apart. So if you remember the first one, the Wagner Act was 35, and then 47 for the Taft-Hartley, and then 12 years later in 59 is the Landrum-Griffith Act, right? And all people. So you got the Wagner, Taft-Hartley, Landrum-Griffith, and Landrum-Griffith Act dealt more with the internal operations of the union. And I think back, and again, you guys weren't alive during any of this, and I guess neither was I, but reading about it, unions were kind of dominated, actually, in a lot of cases by the mafia back in the day, and people that belonged to unions didn't get a chance to even didn't necessarily get a chance to elect their own officials, and so a lot of these unions were controlled by mafia or outside folks, and they kind of controlled what was going on inside the unions and whatnot. And your union dues got paid, and you didn't even know where they went or anything, and there was a lot of corruption. You couldn't look at the finances, you couldn't even ask about the finances, all before 59. So the Landrum-Griffith Act kind of opened up some of those things, right? And it's, again, more of regulations of inside union operations. So financial disclosure. So as a union member, I can call my union, and I've done this. I want to know, what's my dues going for, and they have to give it to me. Okay, gives workers rights against their union. You could sue your union now. You couldn't before 59. We get to vote on our local representation. Okay, those types of things that we get to do now. Okay. So suits against unions that people might bring, right? Unions responsible for actions of its agents. So if the union bigwigs, say, go out and make some errors, maybe they represent us incorrectly against the employer and whatnot, you could sue for that thing. You could get money judgment against the union assets, right? Okay. Members might sue for damages from an illegal strike. So if the union orders you to go out on strike and it turns out it's an illegal strike, you could sue and get damages. Okay. A suit for a breach of duty and a fair representation, failing to enforce union, yeah. Okay, unfair or illegal labor practices by unions. So employers are restricted in a lot of ways, but so are unions, right? You can't restrain or coerce an employee to join a union or to vote to join a union or anything like that. Okay, now union membership can be mandatory under a union shop. Okay, we understand that, but in a right to work state, for example, they can't coerce an employee to join the union. They can't cause an employer to discriminate against a non-union member, and a lot of times that's pre-employment, those types of things. They can't go to the employer and say, here, you have to hire a union member, somebody who's sympathetic towards the union, et cetera, et cetera. So, and they can't strike or picket for illegal purposes or engage in secondary boycotts, okay, or have jurisdictional strikes. Okay, illegal purposes might be, local issues where the union's a bigger union. Okay, secondary boycotts is boycotting, agreeing to boycott another company because it's having a dispute with its union. You can be supportive, but I don't think you can have a boycott. And then jurisdictional strikes are those strikes where it's that's not my job, or that is my job. Okay, and that's where you can't go on strike. You can have arguments about those types of things, whether that's a pipe fitter's job or a boiler maker's job, or whatever the case may be. You can certainly have discussions about those things, but you're not allowed to go on strike, over those types of things. So yeah, again, agreeing to engage in secondary boycotts, union management agreement with adverse effect on a third party. So that would be the union and the management both agreeing, right? Hot cargo contracts has to do with contracts that are coming in. And I've seen some actions kind of like this where maybe union people have refused to unload a ship or whatnot, and maybe in violation of this, but maybe the ship is not a union ship, or the crew members aren't part of the union, right? And so the union members on the dock, the dock workers, don't want to unload it. Interesting, right? Can they do that? Yeah, I don't know. Picketing when not certified, right? So an illegal strike too might be where local people go out. Yeah, they'd go out on strike when it's not authorized by the bigger union, and that can happen, right? Employer recognize another union. If there's a valid election already conducted, unreasonable picketing time frame. So, employees may be a part of one union, but maybe they want to join a different union because there are different unions and representatives out there. So, all right, enough about unions. I know I buzzed over some of that quick stuff because it's probably not going to be on the test. And this one took a long time, so I'm going to say goodbye. It's the end of the semester. Good luck on the final test. And good luck with the rest of your college career.